Picture a damp street in the city. A young woman stands on the pavement. Her hands are cold. She is holding a piece of torn cardboard.
A few words are scrawled across it in thick black marker. She isn't hiding her face. She carries no weapons. There's no secret plot.
If you walked past her, you would simply see a protester. A nuisance to the traffic, perhaps. A minor public order issue at the absolute worst.
But when the police arrive, they do not treat her like a public nuisance. They arrest her under the Terrorism Act.
It sounds like a mistake, an overzealous officer misreading the rule book in the heat of the moment. But it isn't.
The state has quietly placed this woman and the cardboard in her hands into the exact same legal category as hijackers and bomb makers.
And she is not an isolated case. 2,000 people have been swept off the streets in exactly this way. Over 700 are currently waiting in the wings to face a judge.
Their ultimate crime, a speech act, expressing an opinion.
You might expect the justice system to step in, to look at this massive dragnet, to look at the cardboard signs and call it what it is, a gross misuse of extreme power.
For a brief, hopeful moment, a lower court actually did. But then the Court of Appeal stepped in.
Inside a quiet, wood-paneled courtroom, the judges reviewed the rules. They weighed the fundamental right to free expression against the heavy, unyielding machinery of national security, and they firmly reversed the decision.
They ruled that using anti-terror laws to criminalize a sign is perfectly proportionate.
Why would a panel of highly educated judges look at a citizen holding a marker pen sign and legally endorse their treatment as a terrorist? What is the justice system desperately trying to protect beneath that ruling?
The answer isn't a failure of the law. It is the chilling reality of how the law was designed to function.
Sergeant Miller's fingers were numb from the November chill, but it was the weight of the anti-terror arrest paperwork in his patrol vehicle that made his chest feel tight.
He stood across the damp London pavement, watching a 19-year-old girl in a soaked thrift store coat holding a piece of ripped cardboard.
Written on it in smeared black marker was a slogan supporting Palestine Action. Miller was a 20-year veteran. He remembered the acrid smoke and the frantic sirens of the 77 bombings.
He knew what the word terrorism smelled like. It smelled like copper, panic, and burning hair, not wet cardboard and terrified defiance.
Yet the radio crackled at his shoulder, the duty inspector's voice metallic and devoid of hesitation. Moving on the placard, Section 41, Counter-Terror Protocols.
As Miller stepped forward, pulling the heavy plastic zip ties from his belt, the girl didn't even try to run. She just looked up at him, her eyes wide with a mixture of disbelief and quiet terror.
He recited the caution, his own voice sounding alien and hollow in his ears.
As he pulled the restraints tight around her frail wrists, Miller tasted the profound absurdity of his mandate.
The state had traded the pursuit of actual monsters for the bureaucratic convenience of criminalizing kids with markers, and he was the one executing the absurdity, drowning in a sudden, suffocating flush of professional shame.
The disproportionate use of UK terrorism law to criminalize thousands for simply expressing support for Palestine Action highlights urgent concerns about the expansion of speech-restrictive offenses in counterterrorism legislation.
Yeah, and I think we really need to pause on the sheer scale of what we're looking at here in this deep dive.
Absolutely.
Because, 3,000 counterterror arrests in just a single year, mostly for speech acts, that's a fundamental rewiring of how the justice system operates.
Right, it's totally unprecedented.
We're looking at a scenario where a law designed as a last resort defense against mass casualty events is being deployed against ordinary people holding stationary objects.
It really shatters any traditional understanding of proportionality.
Actually, using counter-terror protocols to police a placard is not just overkill. It feels akin to, authorizing a drone strike to enforce a municipal noise ordinance.
That's a stark analogy, but yeah, it fits.
It degrades the gravity of the term terrorism. And to figure out how the law reached this point of extreme elasticity, we have to look at the initial catalyst.
Yeah. We have to map out the origins of the group written on those pieces of cardboard.
Right. And dissect the precise legal mechanism that allowed the state to completely erase the dividing line between property vandalism and international terrorism.
And just quickly, before we get too deep into the weeds, we should make it really clear to you that we aren't taking any political sides today. Whether we're discussing the activists on the left or the state actions on the right, we're strictly unpacking what the sources lay out. We're not endorsing any viewpoints, just reporting on the legal shifts.
We're just looking at the mechanics of the law here. So let's start with the chronological starting point.
Right, so that would be the formation of Palestine Action in July 2020.
Okay, 2020. Who was behind it?
It was founded by Huda Mawari and Richard Barnard. And, their operational philosophy was highly specific right from the start.
In what way?
Well, they did not focus on traditional lobbying or permitted marches. Their exclusive strategy was direct action.
Meaning physical intervention.
Specifically targeting the property, infrastructure, and supply chains of arms manufacturers.
And Elbit Systems was their main target, right?
Elbit Systems is an Israel-based international military technology company, and they operate several manufacturing and administrative facilities across the UK. The activists sought to physically disrupt the production and transport of military equipment that they alleged was being utilized in violations of international law.
And their methodology was inherently disruptive. I mean, the reports detail activists breaking into industrial parks.
Right. Dismantling precision machinery.
Covering corporate facades in red paint, and even occupying factory roofs for days at a time to halt production.
Which obviously caused millions of pounds in financial damage to corporate infrastructure over the years.
Right. But for years, the legal system just handled these actions through standard criminal statutes, right?
Activists were arrested. They were charged with criminal damage, aggravated trespass, or burglary, and they were processed through the normal courts.
So the state recognized them as lawbreakers, certainly,
Sure.
but they categorized them within the traditional boundaries of public order and property offenses.
That was the established equilibrium.
Right, until that equilibrium just totally shattered on June 20th, 2025.
Yeah, the incident at RAF Breeze Norton, that was the ultimate catalyst for the state's massive escalation. So on June 20th, activists associated with Palestine Action actually managed to breach the perimeter of a highly secure Royal Air Force base.
A military base.
And they utilized electric scooters to quickly navigate the expansive tarmac, reaching 2 Royal Air Force Airbus Voyager transport planes.
Wow, electric scooters on an RAF base.
Yeah. And they used fire extinguishers that had been repurposed to spray industrial red paint, and they defaced the turbines of the aircraft and covered portions of the runway.
Just totally coated them.
Exactly. And the group published statements claiming the action was designed to halt what they described as British logistical support for Israeli military operations.
Did the government confirm that?
No. The Ministry of Defense firmly denied that the specific aircraft targeted were involved in any such operations. But honestly, the physical breach of a high-security military installation fundamentally altered the government's calculation.
And the speed of the bureaucratic response to that breach is just staggering.
Barely 2 weeks later.
Right. On July 5, 2025, the Home Secretary, Yvette Cooper, triggered Section 3 of the Terrorism Act 2000.
Yeah.
Palestine Action wasn't just condemned, they were officially proscribed. They were legally designated as a terrorist organization.
But the parliamentary mechanics of how that prescription was cemented into law, that is where the procedural reality becomes incredibly opaque for the average citizen.
Yeah, let's get into that, because the bundling tactic here is wild.
It's a critical component of how executive power functions. You see, the prescription of Palestine Action was not presented to Parliament as an isolated standalone debate.
No, they packaged it.
Exactly. The Home Secretary bundled the group into a single statutory instrument alongside 2 violently extreme, internationally recognized neo-Nazi organizations.
Really? Which ones?
The Maniacs Murder Cult and the Russian Imperial Movement.
Okay, I want to make sure the stark contrast between these groups is absolutely clear for you listening.
Yeah, it's night and day.
The Maniacs Murder Cult is documented as a white supremacist accelerationist network explicitly dedicated to the physical murder of minorities and the instigation of race wars.
Real lethal violence.
And the Russian Imperial Movement is a heavily armed, ethno-nationalist paramilitary organization that actively deploys fighters to combat zones in Ukraine.
Right.
And the Home Office packaged a UK-based anti-arms trade protest group right alongside them in a single, inseparable legal document.
And that packaging tactic forces a highly constrained dynamic upon lawmakers. Because it was presented as a single prescription order, members of Parliament were denied the ability to vote on the groups individually.
Wow, so it was an absolute binary.
Ban all 3 organizations simultaneously, or ban none of them.
That effectively neutralizes any nuanced political opposition.
I mean, if an MP harbored profound reservations about categorizing property-damaging activists as terrorists, voting against the order would require them to simultaneously vote to shield violent neo-Nazi paramilitary networks from counter-terror sanctions.
And the political optics of doing that are essentially unsurvivable.
Consequently, the order sailed through the House of Commons with an overwhelming majority of 385 to 26.
It is a brilliant, if deeply cynical, piece of legislative railroading. But it leaves us with a massive jurisprudential question. How does the legal text actually support this?
Well,
I mean, if you are a judge or a legal scholar looking at the definitions written into law, how do you justify classifying the act of spraying paint into a stationary airplane turbine as an act of international terrorism?
the legal justification hinges entirely on a very specific and highly scrutinized interpretation of Section 1 of the Terrorism Act 2000.
Okay, let's break down Section 1.
So Section 1 outlines the foundational definition of what constitutes terrorism under UK law. Most people intuitively associate terrorism with Section 1, subsection 2, paragraph A, which defines it as an action that involves serious violence against a person.
Yeah, harming people.
But the Home Secretary invoked Section 1, subsection 2, paragraph B, which defines terrorism as an action that involves serious damage to property. Yes, provided the action is also designed to influence the government or intimidate the public for the purpose of advancing a political, religious, racial, or ideological cause.
But wait, that subsection, the serious damage to property part, has been sitting in the statute books since the year 2000.
Yeah.
It isn't some new amendment written specifically for this protest group. So why did legal analysts treat its application in 2025 as this seismic, unprecedented event?
Because the unprecedented nature lies in the historical application of the law, rather than its mere textual existence. Well, when the Terrorism Act 2000 was drafted, the inclusion of property damage was primarily informed by the long history of the conflict in Northern Ireland.
Right, the Troubles.
Paramilitary groups frequently targeted infrastructure, like the bombing of the Baltic Exchange or the Arndale Center.
But even then, there was a difference.
Even when buildings were the primary target, the methodology, high-yield explosives, carried a profound, inherent, and indiscriminate risk to human life.
So the property damage inherently endangered people.
And from the year 2000 all the way to 2025, navigating through the eras of Al-Qaeda and ISIS, the UK government maintained an incredibly high, unwritten threshold for prescription.
Meaning they only banned groups that were lethal.
Every single group banned under the act possessed a clear, explicit nexus with lethal militant violence, assassinations, or mass casualty events.
This is the exact moment the legal architecture shifts on its axis.
Yeah, it really is a huge shift.
For the very first time in a quarter of a century, the state severed that nexus. They prescribed an organization solely and exclusively on the basis of causing serious damage to property,
without any allegation that the group intended to cause human casualties or employ lethal force.
The state effectively collapsed the profound historical distinction between violence against the person and violence against physical infrastructure.
And the collapse of that distinction creates a powerful structural tension within the broader philosophy of the criminal law.
Because normally the law treats those very differently.
Traditionally, criminal codes rigorously separate the moral weight of harming a human being from the act of damaging an inanimate object. The sentencing guidelines reflect this hierarchy.
Right. Grievous bodily harm carries significantly heavier penalties than standard criminal damage.
However, by leveraging Section 1(2)(b) in isolation, the Home Secretary bypassed that traditional hierarchy entirely.
So, by the state's logic, once the threshold of serious property damage is met with an ideological motive, the action is elevated into the exact same legal stratosphere as a coordinated lethal attack.
That's the legal reality now.
This is where the philosophical implications become incredibly difficult to digest. I mean, does the state's rationale genuinely suggest that taking an angle grinder to the perimeter fence of a corporate facility is now legally indistinguishable from detonating a shrapnel device in a crowded public square?
Legally, under the specific use of the Terrorism Act, yes.
If the justice system strips away the fundamental moral distinction between human life and industrial machinery, what happens to the concept of proportionality?
It kind of vanishes.
We are discussing a legal framework that equates the dismantling of a drone engine with the taking of human life.
Yeah.
And the moment that expansion occurs, the consequences do not remain confined to the activists holding the angle grinders.
No, they don't. That is the critical transition point we have to look at. Once a group is officially prescribed under this newly expanded definition of terrorism, the secondary layers of the Terrorism Act 2000 are instantly activated.
And these secondary layers are massive.
They cast an incredibly broad, sweeping net over the entire civilian population. Proscription fundamentally transforms the legal status of mere speech, association, and expression.
So let's analyze the specific machinery of that net.
Yeah.
Once the proscription order was finalized by the Home Secretary, Sections 11, 12, and 13 of the Act immediately came into force. These are the mechanisms that actively target the public square.
Right. So Section 11 establishes that simply belonging or professing to belong to the proscribed organization is a serious criminal offense.
Which makes sense for a terror group.
But Sections 12 and 13 represent the most aggressive curtailment of civil liberties.
Let's start with Section 12.
Section 12 historically made it an offense to invite support for a banned group.
Like recruiting for them.
Right. However, following amendments introduced in 2019, the scope of Section 12 was drastically widened.
Oh, what?
It is now a criminal offense to express an opinion or a belief that is supportive of a proscribed organization, provided the individual is acting recklessly as to whether a person hearing or reading that expression will be encouraged to support the group.
Wow. And the penalties attached to these speech acts are not minor misdemeanors. The maximum penalty for expressing a supportive opinion under Section 12 is 14 years in prison.
14 years.
You could face a decade and a half behind bars for articulating a political viewpoint on a public street.
And then you must factor in Section 13, which is perhaps the most legally complex and perilous mechanism for the average citizen.
Okay, lay out Section 13 for us.
Section 13 creates what is known as a strict liability offense regarding the wearing of clothing or the display of articles in public.
Wait, I think the concept of strict liability needs to be clearly defined here because it contradicts how most people assume the justice system works. If you are charged with a crime, you generally assume the prosecution has to prove you actually intended to commit it.
Under standard criminal law principles, you are correct. The prosecution must prove mens rea, or a guilty mind.
Right.
But a strict liability offense removes that requirement entirely. Under Section 13, your personal intent is legally irrelevant. If you wear an item of clothing, carry a flag, or display a logo in a manner, or in such circumstances as to arouse reasonable suspicion that you are a member or supporter of a prescribed group, the offense is complete. The court does not need to prove you intended to support the group. They only need to prove that a hypothetical reasonable observer, which is often just a police officer on duty, could look at you and form a suspicion of support.
And what's the penalty for that?
The penalty for this strict liability offense is up to 6 months imprisonment.
6 months just because an officer formed a suspicion, regardless of what you actually meant. And this abstract legal theory violently collided with reality almost immediately.
It didn't take long at all.
In August and September of 2025, a massive wave of citizens organized under the banner of a separate campaign called Defend Our Juries. They organized peaceful sit-ins in highly visible locations like Parliament Square and Trafalgar Square, specifically to protest the proscription order itself.
They viewed the ban as an assault on the right to protest.
And the state responded by deploying counter-terror police to clear the squares.
And the demographic profile of the individuals caught in that dragnet is deeply revealing regarding how indiscriminately the law was applied.
Who were they arresting?
Well, the police were not arresting clandestine paramilitary operators, that's for sure. The records show the arrest of an 83-year-old retired Anglican priest, Reverend Sue Parfit.
An 83-year-old priest.
They arrested a sitting magistrate. They arrested primary school teachers.
Just normal citizens.
In Edinburgh, the acclaimed screenwriter Paul Laverty was detained for wearing a T-shirt bearing the slogan, "Genocide in Palestine, time to take action."
Just for a T-shirt. But the absurdity really reached a peak with the arrest of a man who decided to mock the ban entirely.
Oh, the plasticine guy.
He printed a T-shirt that said, "Plasticine Action," a pun on the children's modeling clip.
Making fun of the Palestine Action name.
And he was swept up by counter-terror officers, processed, and only later de-arrested when the sheer ridiculousness of prosecuting a pun under national security legislation became apparent.
But the fact that the initial arrest happened at all demonstrates how the mechanisms of Sections 12 and 13 function in the field.
Yeah, the police are given a sledgehammer and instructed to swat flies.
The sheer volume and arbitrary nature of these arrests inevitably triggered an emergency judicial review.
Which brings us to February 2026.
On February 13, 2026, the issue reached the High Court. A panel of senior judges was tasked with examining the legality of the Home Secretary's initial proscription order.
And they did something really surprising.
Very surprising. In a highly unusual move, the panel delivered a unanimous ruling declaring the proscription of Palestine Action to be fundamentally unlawful.
When you read the High Court's reasoning, it feels like a sudden, desperate gasp of oxygen for civil liberties. The judges looked at the mountains of arrest paperwork, the pensioners and teachers being criminalized for holding pieces of cardboard, and concluded that the state had crossed a dangerous line.
The High Court's analysis centered heavily on the European Convention on Human Rights, specifically Article 10, which guarantees freedom of expression, and Article 11, which protects freedom of assembly.
Did they say the activists didn't cause damage?
No, the judges did not deny that certain activists had committed property damage offenses.
Okay, so they acknowledged the vandalism.
However, they ruled that bringing the full, crushing weight of the Terrorism Act down upon the entire organization, and by extension, criminalizing any public expression of support for their underlying cause, constituted a vastly disproportionate interference with those fundamental democratic rights.
And the core of their argument rested on understanding a concept known as the chilling effect. This isn't just about the people who actually get arrested. It is about the psychological impact on the millions of people watching those arrests happen.
The chilling effect is the invisible consequence of overly broad legislation.
How does it actually work in practice?
Well, because Section 13 relies on the subjective, reasonable suspicion of an individual police officer, it creates an environment of total legal unpredictability.
So you literally can't know what's illegal.
If you are a citizen contemplating attending a rally and you want to bring a generic homemade sign that says "Stop Arming Israel" or "Free Gaza," you face an impossible risk assessment.
Because you don't know who is reading the sign.
Right. You have no way of predicting whether the specific officer stationed on that corner will interpret your generic sign as arousing a suspicion that you secretly support the proscribed methods of Palestine Action.
The threshold for triggering a counter-terror arrest is entirely subjective and opaque. So, faced with the prospect of being handcuffed under the Terrorism Act, having your DNA logged on a national security database, and facing a potential 6-month sentence over a misunderstanding.
Well, what does a rational citizen do?
You stay home, you leave the cardboard in the recycling bin.
The state doesn't even need to arrest you. The ambiguity of the law does the policing for them. Furthermore, the legal analysis points out that this chilling effect rapidly migrates from the physical streets into the digital architecture of the public square.
The internet.
This is largely due to the interaction between the Terrorism Act and newer legislation, such as the Online Safety Act 2023.
Because that act places immense pressure on social media platforms and technology companies to actively scrub their networks of anything that constitutes a terrorism-related offense.
And because Section 12 makes it a terrorism offense to recklessly express an opinion supportive of a proscribed group, the tech companies are suddenly forced to act as the ultimate arbiters of political speech.
Right? Because content moderators and automated algorithms do not possess the nuanced legal training to carefully parse the subtle boundary between legitimate, robust political dissent and a criminal violation of Section 12.
Not even close.
Yeah.
To shield themselves from massive regulatory fines and corporate liability, these platforms adopt a policy of aggressive over-removal.
They just nuke everything that sounds close.
They program their algorithms to sweep up vast amounts of completely lawful political discourse that merely utilizes similar keywords or hashtags.
So the digital net cast by the tech platforms is often exponentially wider than the net cast by the police.
The argument emerging from this scenario is that the law acts like a contagion.
A contagion.
Proscription in this context is not a surgical strike directed exclusively at a few dozen activists breaking windows at an industrial park. It operates like a virus that infects the entire ecosystem of public discourse.
It transforms ordinary citizens who are simply trying to express basic political dissent or moral outrage into the collateral damage of a sprawling national security apparatus.
And the High Court recognized this cascading effect and attempted to halt it by quashing the ban.
But that wasn't the end of it.
Oh, within the structure of the UK legal system, that ruling was merely a temporary reprieve.
The Home Office immediately appealed the decision, escalating the confrontation to the Court of Appeal.
Right. And this transition forces us to examine the deeper structural realities of how the judiciary handles matters of national security. The Court of Appeal's strained reasoning to uphold a proscription order while avoiding a finding of disproportionate interference with free expression reveals a structural bias within judicial review of national security measures that prioritizes state powers over individual rights.
To understand the atmosphere of that appellate process, consider this scenario from behind closed doors. The glow of the desk lamp in the Royal Courts of Justice casts long, skeletal shadows across the mahogany desk. Eleanor, a junior clerk, rubbed her burning eyes, staring at the 5th draft of the appellate judgment on her monitor.
Her mandate from the presiding judge was inherently contradictory. She had to find the precise legal phrasing to uphold the state's absolute ban on the protest group, while simultaneously insisting that the public's fundamental right to free expression remained entirely unviolated.
It was an exhausting exercise in linguistic contortion. She typed, deleted, and retyped, watching the jurisprudence twist itself into a pretzel to avoid upsetting the Home Office.
The High Court below them had dared to call out the disproportionate nature of the ban. But here on the appellate floor, the air was thinner, and the gravitational pull of state security overrode the fragility of individual rights.
Eleanor highlighted a paragraph she had just written, a strained piece of logic, effectively arguing that freedom of expression wasn't violated because people were still perfectly free to hold opinions in their heads, so long as they didn't voice them publicly in a prohibited manner.
A cold, heavy numbness washed over her. She realized with a quiet sickness in her stomach that she wasn't drafting a pursuit of justice.
She was building an elegant, impenetrable, rhetorical coffin for civil liberties, sanding down the edges so the public wouldn't get a splinter when the lid finally slammed shut.
And that atmospheric description heavily reflects the reality of the judgment handed down on June 15, 2026. A deeply powerful 5-judge panel at the Court of Appeal, led by the Chief Justice, Baroness Sukar, systematically dismantled the High Court's ruling.
They completely overturned the lower court and reinstated the total prescription of Palestine Action.
They did.
The whiplash is disorienting. I mean, you have to wonder how 5 of the most senior legal minds in the country could examine the exact same evidence, the arrests of the pensioners, the strict liability charges for holding signs, and conclude that the state's actions were perfectly balanced and lawful. How does the legal machinery justify that reversal?
Legal scholars point to a phenomenon often described as deference to the executive. Well, in the arena of national security, appellate courts possess a deep-seated structural bias. Judges are acutely aware that they are unelected officials, and they generally believe that the elected government, specifically the Home Secretary, is better positioned to assess threats to the state and determine the necessary responses.
So they just back off.
When the government invokes the terminology of terrorism, the courts are historically incredibly reluctant to intervene and strip the state of its defensive tools.
But in this specific case, the appellate judges found themselves ensnared in a profound structural logic trap.
Yes, they did.
Let's carefully unpack the mechanics of that logic trap. What exactly cornered the judges?
The trap is created by the inflexible nature of the Terrorism Act itself. Proscription is a blunt, indivisible legal instrument.
Indivisible.
When a group is banned, it grants the state a monolithic bundle of powers all at once. The ability to freeze financial assets, the ability to impose extended prison sentences, and the draconian speech restrictions under sections 11, 12, and 13.
So they get all of it or none of it.
The law does not allow a judge to act selectively. If the Court of Appeal were to agree with the High Court that the speech bans were a disproportionate violation of human rights, the only legal remedy available to them would be to strike down the proscription order in its absolute entirety.
They can't act as an editor.
No.
They can't look at the law and say, the asset freezing is fine, the increased surveillance is fine, but we are going to cross out Section 12 because arresting people for holding signs goes too far.
The legal framework prohibits an a la carte approach. Striking down the speech restrictions requires stripping the Home Office of every single counter-terror power it held against Palestine Action.
And the appellate court, operating under that principle of deference to the executive, was simply unwilling to disarm the state in that manner.
Exactly. Therefore, to preserve the core of the state security apparatus, the judges were forced to reverse engineer their logic.
They had to construct highly strained, circuitous arguments to mathematically prove that arresting thousands of people for holding placards did not actually constitute a disproportionate attack on free speech.
Yeah.
The intellectual gymnastics required to make that argument seem almost impossible. How do you draft a legal document that looks at a sprawling dragnet of nonviolent citizens and declares their right to expression is completely unharmed?
The court achieved this by drawing a highly artificial distinction in their written judgment. They argued that the proscription decision does not, as a matter of strict law, prevent citizens from publicly expressing support for the broader Palestinian cause.
Okay, so they're saying you can still be generally supportive.
They stated it does not criminalize general opposition to the State of Israel, nor does it ban lawful, permitted demonstrations against international arms companies. The court's logic dictated that the law only prevents support for this specific proscribed entity and its specific methods. Therefore, they concluded, the overarching fundamental right to freedom of expression remains robustly intact, merely channeled away from one prohibited avenue.
But the criticism of that logic is devastating. It is akin to a surgeon performing a...
And the argument is that the appellate courts, in this instance, function less as impartial arbiters defending constitutional rights and more as the ultimate shield validating executive overreach.
And to insulate that controversial validation from public backlash, the Court of Appeal did not rely solely on dense statutory interpretation.
They actively engaged in historical framing. The inclusion of historically inaccurate generalizations about suffragettes in the Court of Appeal's judgment underscores a broader problem of judges relying on oversimplified historical analogies to justify limitations on civil liberties.
To understand how deeply history was manipulated in that courtroom, let me set the scene from the perspective of an observer watching it happen. Arthur sat near the back of the wood-paneled courtroom, a university historian masquerading as an idle spectator, listening as the Lord Justice read the final judgment aloud.
When the magistrate smoothly invoked the suffragettes to justify the court's strict boundaries on civil liberties, Arthur felt a muscle twitch violently in his jaw.
The judge painted a polite, sanitized picture of the women's movement, an oversimplified historical fiction carefully curated to contrast against the unprecedented and unlawful disruptions of Palestine Action today.
Arthur's own great-grandmother had done hard labor in Holloway Prison for smashing the windows of a government building and plotting arson.
Yet here was a man in a horsehair wig stripping the radical blood, fire, and property damage from history to weaponize a sterilized past against the activists of the present.
The judge's voice droned on, calm, cultured, and authoritative, implicitly suggesting that proper civil disobedience never truly inconvenienced the machinery of the state.
Arthur looked down at his scuffed shoes, overwhelmed by a sudden, paralyzing exhaustion.
History was not being honored in this room. It was being meticulously hollowed out, worn like a respectable skin suit by the very establishment that would have locked his great-grandmother away under the exact same modern terrorism laws without a second thought.
The historian's reaction in that scenario highlights a pervasive rhetorical tactic utilized by the judiciary.
When seeking to define the acceptable limits of contemporary protest, judges frequently invoke past, victorious movements, such as the suffragettes or the American Civil Rights Movement, as the absolute gold standard of democratic dissent.
They use these historical touchstones to construct a baseline of acceptable...
Exactly. And against that baseline, modern activists are inevitably found to be dangerously radical, deviant, and therefore deserving of severe punishment.
But the version of the suffragettes that the court relies upon to build that baseline is practically a fairy tale.
It's totally sanitized.
The judgment implies a movement of polite Edwardian women respectfully petitioning the government for the right to vote.
Which is just not what happened.
The historical reality is that the militant wing of the suffragette movement, particularly the Women's Social and Political Union, executed highly organized, relentless campaigns of brutal direct action.
They did not just hold signs.
No, they systematically smashed the windows of commercial districts across London. They chained themselves to government railings.
They escalated to extensive arson campaigns,
setting fire to the empty homes of politicians and dropping acid into the public postal system. They even detonated a bomb at the country home of the Chancellor of the Exchequer, David Lloyd George.
And their explicit, stated strategy was to inflict severe economic and property damage to force political capitulation.
The legal irony here is profound. If the Terrorism Act 2000, with its specific inclusion of Section 1(2)(b) regarding serious damage to property, had existed in 1912...
the suffragettes would have unambiguously met every single criteria for immediate proscription.
Their actions were designed to influence the government, advance a political cause, and involve massive property destruction.
Yet, a century later, the court sanitizes their legacy, erasing the fire and the shattered glass, in order to argue that modern activists targeting corporate property are committing an unprecedented deviation from the norms of civil disobedience.
And the state's historical amnesia isn't limited to events from a century ago either. Legal observers point to much more recent parallels that expose the shifting standards.
Consider the mass anti-war protests that erupted in 2003 leading up to the invasion of Iraq. The 2003 protests offer a highly relevant and starkly contrasting legal precedent. During that period, activists successfully breached the perimeter of RAF Fairford,
another military base.
And their objective was to physically prevent American B-52 bombers from utilizing the base. They intentionally caused serious property damage to military infrastructure, targeting fuel tankers and bomb trailers. They utilized bolt cutters and abrasive materials to sabotage equipment. And the resulting legal battle reached all the way to the House of Lords.
And the details of that legal defense are fascinating. Do you know who represented one of the key defendants in that 2003 case? Pierce Starmer, before his political career. But the most crucial detail is how the state chose to prosecute the activists. Despite the fact that they had breached a military base and destroyed government property during a time of international conflict, the prosecution made absolutely no attempt to invoke counterterrorism legislation.
There were no accusations of terrorism.
The entire affair was handled strictly as a matter of criminal damage, aggravated trespass, and public order offenses.
The contrast is impossible to ignore. 20 years ago, infiltrating an RAF base to damage equipment in an attempt to halt a war resulted in a standard criminal trial, vigorously defended within the normal parameters of the law.
And today,
infiltrating an RAF base to deface equipment in an attempt to halt a war results in the entire organization being legally branded as a terror syndicate, bundled in legislation alongside white supremacist death squads.
By actively sanitizing the past, the state successfully manufactures a false, tranquil baseline.
It creates a powerful illusion for the public that modern property disruption is somehow an alien, uniquely terrifying threat to the fabric of democracy.
It is an argument that suggests the justice system has constructed a museum of acceptable dissent.
A museum, right?
Within the walls of this museum, radicalism is celebrated and honored, but only once it is safely dead, entombed in the past, and utterly incapable of disrupting the current status quo.
We erect statues of the suffragettes in Parliament Square, but the exact same tactical framework they pioneered is prosecuted today with the most devastating legal weapons the state possesses.
And the transition from those theoretical historical debates within the appellate court to the devastating physical reality on the ground is where the true weight of this legal evolution is felt.
While judges dissect the nuances of historical precedent in quiet wood-paneled rooms, the individuals swept up in this expanded terror dragnet are subjected to severe, life-altering consequences.
The escalation of state repression moves from paper to concrete. Let's examine the raw physical impact of this legal architecture. The Filton 24 case represents the sharpest edge of this escalation.
Right, August 2024.
In August 2024, a highly organized group of activists executed a raid on Elbit Systems' Aztec West site near Filton. They utilized a repurposed prison van to ram through the outer security fences, breach the facility, and cause substantial methodical damage to the interior infrastructure.
And during the chaotic confrontation with responding police forces, an officer suffered a fractured spine.
The immediate response from the justice system demonstrated a clear departure from standard criminal procedure. The activists involved were arrested and, remarkably, denied bail.
Denied bail completely.
Many of them were held on brutal remand for over 18 months while awaiting trial. To contextualize that for you, 18 months is double the standard legal custody time limit in the UK.
Double the limit. Furthermore, they were not held in standard remand facilities.
Where were they?
Many were placed in high security conditions, typically reserved for the most dangerous violent offenders within the penal system.
The pretrial punishment alone was immense, but the true paradigm shift occurred during the sentencing phase in May 2026.
Right. This is the moment where the newly expanded legal architecture truly revealed its teeth.
So the trial resulted in 4 of the Filton activists being convicted of severe criminal damage and 1 activist being convicted of grievous bodily harm without intent in relation to the injured police officer.
Based on standard sentencing guidelines for those specific offenses, legal analysts anticipated significant but predictable prison terms.
Instead, the presiding judge handed down sentences totaling an astonishing 24 years.
24 years.
This massive, unprecedented escalation was achieved through a highly controversial legal mechanism. The judge secretly applied a terrorism connection enhancement to their standard criminal convictions.
The procedural aspect of that enhancement is incredibly difficult to comprehend. I mean, how does a judge secretly apply a terrorism label to a case?
The controversy stems from the timing and the transparency of the decision. The legal records indicate that the decision to apply this terrorism enhancement was finalized by the judge months prior to the conclusion of the trial. However, it was kept entirely hidden from the jury and the public until after the guilty verdicts for criminal damage were formally secured. Throughout the duration of the trial, the defense was subjected to strict gag orders regarding their motivations.
Gag orders?
Yeah. The defendants were legally prohibited from explaining to the jury why they had attacked the facility. They could not mention the conflict in Gaza, they could not discuss Elbit Systems' international supply chains, and they could not articulate their deeply held belief that their actions were a desperate attempt to prevent violations of international law.
So the entire political and moral context of their actions was surgically stripped away from the proceedings.
Only after the jury returned a verdict on the raw facts of the property damage did the judge suddenly drop the terrorism enhancement onto the sentencing phase, radically multiplying the prison terms.
And analysts note, this was the very first time in UK legal history that a terrorism enhancement was applied to offenses rooted in political protest.
Let's crystallize what that means. The state did not have the confidence to formally charge them with terrorism offenses in front of a jury, where they would have to prove the elements of a terror charge beyond a reasonable doubt.
Right. Instead, they tried them for standard property crimes, secured the conviction in a politically sterilized courtroom, and then punished them as if they were convicted terrorists at the final moment.
It is an end run around the burden of proof. And the psychological impact of that sentencing strategy triggered a desperate wave of resistance from within the prison walls themselves.
Mass hunger strikes broke out across some of the most secure facilities in the country, including Bronzefield, Belmarsh, and Franklin.
The sheer physical endurance demonstrated by the hunger strikers highlights the profound desperation of their situation.
The public records detail the grueling timelines. You have individuals like Kamran Ahmed, Tuta Hoxha, and Louis Caramello enduring agonizing weeks without sustenance.
And the most extreme case documented was Heba Maraisi, right?
She maintained her hunger strike for an astonishing 73 days.
73 days.
The medical realities of a 73-day strike are catastrophic, organ failure, severe cognitive impairment, irreversible physical damage.
The strikes forced the reality of the legal situation into the international spotlight, culminating in mass solidarity protests outside the prison gates.
And those protests inevitably led to further arrests under the sweeping public order laws,
including the highly publicized detention of international climate activist Greta Thunberg in London just days before Christmas in 2025.
When we pull back and look at the macro picture, the systemic threat becomes undeniable.
Because we are watching the criminalization of political protest operating under the impenetrable cloak of counterterrorism.
What happens to the fundamental structure of a democracy when the legal system begins to cannibalize its own principles of proportionality in order to protect corporate infrastructure?
The systemic danger lies in the establishment of irreversible legal precedent.
Because when you classify the dismantling of a drone engine or the defacing of an industrial park as an act of terrorism, the threshold is permanently, structurally lowered for every future movement.
The law does not exist in isolation. If the legal reasoning utilized to prescribe Palestine Action is accepted as valid jurisprudence, it inevitably creates a blueprint for the suppression of entirely different spheres of civil society.
The extrapolation of this logic is the most alarming aspect.
Let's follow that extrapolation. If the legal definition of terrorism is now untethered from lethal violence and securely anchored to serious damage to property for an ideological cause, there is no structural firewall preventing the state from applying these exact same terror laws to the environmental movement.
None at all. When activists from Extinction Rebellion shatter the reinforced glass of a fossil fuel headquarters, or when members of Just Stop Oil cause severe economic disruption by damaging corporate energy infrastructure, they are, by definition, causing serious damage to property to influence government policy.
Under the exact precedent established by the Court of Appeal in 2026, the state possesses the fully validated legal authority to declare them international terrorists.
The architecture of repression is fully constructed, tested, and legally validated by the highest courts in the land.
The tools are waiting on the workbench. It merely requires the political will of a future Home Secretary to pick them up and apply them to the next group that causes sufficient inconvenience to the economic status quo.
The analysis suggests the state has fundamentally altered the social contract regarding dissent.
This isn't a localized legal dispute about a single protest group angry about a specific international conflict.
No, the events of 2025 and 2026 map out a new, terrifying architecture of domestic control.
The definition of a terrorist has become infinitely elastic, capable of being stretched and contorted to encompass whoever happens to be challenging the establishment on any given day.
The journey we have traced today is profound.
We moved from the theoretical, a teenager holding a marker-penned piece of cardboard on a damp street, to the brutally concrete reality of a judge handing down a 24-year prison sentence through the use of secret terror enhancements.
It exposes a justice system in the midst of a fundamental realignment, a system that increasingly places the absolute protection of property, supply chains, and executive authority far above the preservation of historical civil liberties and freedom of expression.
The ultimate tragedy of this legal evolution is that the monumental frameworks of counterterrorism, tools designed exclusively to save democratic societies from apocalyptic, lethal violence, have been quietly repurposed as administrative bludgeons to enforce absolute compliance. We're witnessing the dawn of an era where the state demands a monopoly not merely on violence, but on disruption itself, ensuring that the only legally permissible form of dissent is the kind that goes entirely ignored.